Hello, I'm Andrew Flushy. One issue that comes up in a lot of traffic cases are roadblocks or checkpoints that the police set up. So I wanted to talk to you about one issue that comes up with those roadblocks. There's a lot of legal points that come up, but one issue is what happens if a defendant turns around before coming to the roadblock. So you're driving along and for whatever reason you make a turn off the main road or make a U-turn away from the roadblock. Can the police still legally stop you and uphold whatever they find? So if they stop you and determine that you're intoxicated, go ahead and make a DUI arrest. Or if they stop you and determine that you're driving on a suspended or revoked license, can they go ahead and issue an arrest summons for that behavior? The answer is that it's very complicated, like a lot of things in the law. There's a whole line of cases that deal with people who initiate traffic maneuvers before a roadblock. The cases differ based on a lot of factors. And so I wanted to try to give you my thumbnail summary of the rule. Basically, the further away from the roadblock that you make a traffic maneuver, the more likely it's going to be unreasonable for the officer to stop you, claiming that you're trying to evade the roadblock. And that stands to reason because if there's lots of turnoffs and you make a maneuver 1,000 feet or 3 football fields from the roadblock, it's going to be less likely that you're trying to evade the roadblock and more likely that you're just going about your business. There's one case in particular where a gentleman was driving along and there was a roadblock up ahead, and the officer saw him pull into a gas station, drive through the parking lot seamlessly, and then pull back out onto the road going away from the roadblock. The officer stopped him thinking he was evading the roadblock, and I can't remember what exactly they found was wrong and the reason for the case, but the point is that the judge found that that was not a valid stop due to claiming to evade the roadblock because it was so far away. The gentleman didn't pause or anything. He just simply pulled through the parking lot and changed direction. There are other cases, however, where a defendant was within, say, 100 or 200 feet of the roadblock and did something that's a little bit suspicious. In some cases, the defendant might have paused for a second or two and then made a turn. In some cases, the defendant actually gets out of the vehicle and kind of stares at the roadblock. And in those types of cases, the judges normally say that that is a reasonable suspicion for the officer to actually stop you and see if you're doing something criminal, because it does give them some extra element other than just making a legal traffic maneuver. But the cases are pretty uniform in that if all you do is make a legal traffic maneuver a good distance from the roadblock, it's likely that that would be found to be an invalid stop of your vehicle. And the end result there is that if the stop is invalid, we should be able to suppress any evidence that was attained during that stop, because that's what we call fruit of the poisonous tree. If the search or the stop is invalid, everything from that should be suppressed against you, in the case. And if it's a driving on suspended case or a DUI case, that could mean that the whole case goes out the window and you walk away from it. Now, this is obviously a case-by-case analysis. It depends upon the facts of your case and exactly of what you did and what the officers testified to. But it's definitely something that if you're stopped, before you approach a roadblock, then it's something we definitely would look into and try to see if we could suppress the evidence against you.